All right, great. Good evening, good afternoon, and good morning. I know there are a lot of viewers from different jurisdictions who are going to be viewing this debate. So hello, thank you for joining us on YouTube. Today we are going to be talking about something that is very topical in a debate format. And I'm going to only explain the rules of the debate.
All right, great. Good evening. Good.
I'm going to, apologies for that. That's for the YouTube live, and hello again. What we're going to do today is essentially do an open floor debate. Part of the purpose of the classroom and the Jindal Global Insolvency Law Working Paper Series has been to generate discourse through different modalities, be it policy, practice, and conversation, and a debating format involves all three. Our format for today essentially starts with an initial poll on understanding what the general opinion is on the topic of debate, opens the floor for the for team to convince on a yes, and opens the floor for the against team to convince on a no. Subsequently, we'll do another poll on the basis of which team has been able to convince the participants who are viewing this debate on a yes or a no, and therefore, in terms of victory, they go back home satisfied because then we have no virtual presence to provide. On our debating team, as an introduction to our debating team and our speakers for today, of course, they do not need any introduction, so I will just keep it very, very brief. They are all notable names in the space of insolvency law, and therefore one could not think of a better way to kickstart a virtual debate other than having these four individuals as part of the launchpad. First up, we have the for team, which is Aparna and Sumanth. Aparna is a partner at Samvad Partners. Sumanth is the managing partner of Kesar Das and Associate, Kesar B Das and Associates, and both names in international academia and policy. The against team has Veena Shivaramakrishnan and Sudeep Mahapatra, both partners at top-tier leading firms. Veena with Shardul Amachan and Mangaldas, and Sudeep with SNR and Associates. Our motion for today, in terms of the debate, is circled around Section 29A of the Insolvency and Bankruptcy Code, with whether this House believes that related party bidders and Section 29A exclusions are effective for insolvency resolution. Now, during the course of the debate, I will throw up the motion as a part of the share screen so that people can also make their own opinions about whether they agree with each of the debating team's perspectives or not, and accordingly, they can share their own vote on a yes or no. This is for those who are watching us on YouTube. Without further ado, I'm going to just start with the first poll and then invite the four teams' first speaker, Aparna, to take over and kickstart the debate. In terms of just rules of the debate, each team will get overall 20 minutes per speaker, largely divided into 10 minutes, with a 5 to 7 minute timeline for rebuttals. I will moderate this debate and obviously keep track of time. Please pardon the interruption, but interrupt you if you go over the time. If there are no questions from the debating teams, I can throw open and start with the poll.
Please go ahead, Ishan.
Yep. All right, great. IT, can we please put the poll? So we have 10 seconds for all of you to finish the poll. All right. All right. We will be ending the poll now. Clearly, we are in favor of 4. So we're starting with 4, and let's see how this goes. Aparna, over to you.
Thank you, Shana, and good afternoon, everyone. I'm delighted to participate in the debate today for Section 29A and the proposition that related party bidders and Section 29A exclusions are effective for insolvency resolution. So I'm going to first start with, we all know that the IBC is not just a recovery mechanism. The point is not just for creditors to recover their dues from the process, but it's also a resolution mechanism that places equal emphasis on turnover of the corporate debtor or the debtor company that's in the resolution process. So it's important that we care about not just whether a resolution plan comes to the table, whether a resolution plan is approved, but also whether it's actually goes further than that and is implemented. We wouldn't want a situation where a resolution plan is approved and then the resolution applicant fails to pay up or implement the plan. We also don't want a situation where the resolution plan is approved, implemented, and then the debtor comes back knocking at the door again of the NCLT, or the company comes back into insolvency a few years later. So for all these reasons, and given the importance of the resolution process and the fact that it's as much focused on the turnaround of the corporate debtor and not just on the recovery of dues for the creditors themselves, it makes a lot of sense. It's essential that there are some eligibility criteria for resolution applicants, that it cannot be entirely open to anybody to be a resolution applicant. And this is what Section 29A seeks to do. And many of the exclusions under 29A are basically for various groups of individuals with questionable antecedents who perhaps may not be the best qualified to actually submit a bid and then bring a company out of the very distressed financial situation it's in. So some of these, as we all know, include applicants with certain kinds of criminal convictions, those who are disqualified from accessing the securities markets, those who have been disqualified from being directors, etc. In addition to that, and the primary contention in today's topic and the main area of a lot of debate in around 29A deals with the question of related party bidders. And this specifically relates primarily to sections 29A, subsection C, and subsection H. So subsection C talks about the situation where promoters of a company or anyone who holds an account that has been an NPA or is a promoter of the corporate debtor that has had an NPA for at least a year cannot then submit a bid and cannot be a resolution applicant unless at the time of submitting the resolution plan, those NPAs are cleared. And 29AH talks about guarantors and those who have given guarantees for a corporate debtor that's in an insolvent situation, and in that situation where the corporate guarantee or a corporate or personal guarantee is invoked and hasn't been paid. So why is it important to restrict these kinds of individuals or these kinds of applicants per se from bidding in a resolution plan? I think the single biggest reason and the thinking behind Section 29A itself is the simple rationale that individuals who have contributed to the financial distress of a company. And remember, this financial distress doesn't stop. Its impact is not limited to the company itself. It goes far wider to its stakeholders and its creditors, both financial creditors and operational creditors. Such a person, such an individual, should not then be allowed to benefit from the corporate insolvency process by being able to come back into the management, come back to acquire the company at a much lower price and at the expense of creditors, financial creditors, operational creditors, all the other stakeholders who have had to bear haircuts, who don't get paid their full amounts. And then this individual comes back into the company and there is nothing and there's nothing further that he needs to do. There is no other sort of recourse against that individual for what he's done. So in this situation, there seems to be something obviously wrong here, but not really going into the moral issues or any other justification, but just looking purely at what has been one of the primary impacts. And, one situation where the IBC has been particularly effective is the fact that it has brought about a change in promoter behavior. And there are lots of anecdotes and stories about this, as well as data that shows that the behavior of promoters with regard to debt and how they have viewed their relationship with creditors has undergone a dramatic change since the IBC came into effect. Previously, once a company had the funds, there was a saying that cash is king, and there is promoters didn't really fear the threat or the repercussions of defaults. That has obviously changed since the IBC came into effect, and that is one of the biggest successes of the IBC itself. And I'd like to pose the question to all of you: if 29A did not exist, would we see a similar sort of change in promoter behavior? And I believe the answer would very likely be no. If a promoter were to believe that even if their company was taken into insolvency, they could very easily get out of it without having to suffer the consequences at all. And in this, it's important to note that Section 29A does not does not involve a blanket ban on promoters being able to submit resolution plans. It is only in the case where they have an NPA, if they do make it good, they are free to submit a resolution plan. So in this situation, I think the single most important reason to retain 29A is because of the behavioral change, the impact it has on promoter behavior, that they are much more likely to be careful even prior to coming into the IBC process, because they know that once that process begins, it's not going to be easy for them to regain control of the company. Related to this, and a slightly different but also important point, is that the purpose of the IBC is also to encourage debt resolution, encourage a large, diverse group of investors and entities coming in and submitting resolution plans, including third-party bidders. And if we didn't have such restrictions on promoters from submitting bids, I think the playing field would be, it would not be a level playing field at all, and it would really discourage third-party bidders from coming forward in this situation. And the reason for this is that as a promoter of a company, particularly in the Indian context, there's a lot of information asymmetry between what the promoters have, the information the promoters have, and what is available to, say, third-party resolution applicants, third-party bidders. And in this situation, without these sort of restrictions on promoters, on related party bidders, it would be very difficult for a lot of, it would really discourage third-party bidders who would otherwise be very well placed to manage the company, submit bids, from coming forward. And this is the second reason that I think it's very important that 29A be retained. Coming now to the crux of all of this, which is really, I think a lot of people would say, yes, 29A makes sense to a certain extent to exclude certain groups of or individuals or entities from submitting resolution plans. But the question that keeps being asked is, has the net been cast too widely? Does it inadvertently restrict various bidders who would otherwise, should not be ineligible to submit plans? And does it, because of this, significantly narrow the pool of resolution applicants? In my view on this point, while perhaps the initial Section 29A that was part of the 2017 ordinance may have been overly broad in some certain situations, there have been subsequent amendments to the section that have corrected for these this overreach. And some of them, for example, it's been made very clear that financial entities who may be, hold equity in a corporate debtor, for example, or regulated financial institutions would not be covered under the exclusions in Section 29A. Similarly, there are also exclusions for entities or individuals who have NPAs because they have previously submitted and been successful in acquiring another debtor pursuant to a resolution plan. Similarly, those exclusions that are very personal to the individual concerns, such as, say, a disqualification from a directorship, in those situations, the connected persons are excluded from going beyond, and it doesn't extend that far to connected persons. So there has been a lot of scaling back of Section 29A. And lastly, I should also mention the exceptions for the MSME sector, which functions on very different economics and doesn't have the wide pool of third-party bidders that would be available to other typical corporate debtors. And in those cases, again, 29AC and 29AH are not applicable. So right now in this state, 29A is, I believe, critical for the success of resolution plans, and also in bringing about discipline in the corporate resolution process and in its impact it has on promoter behavior. Before I turn it over to my team member, Mr. Sumant Batra, one last thing I want to say is that today the market has, while initially, like any other law, it takes some time for the market to get used to it, understand how to monitor Section 29A and how to sort of account for it in the bidding process. That time has now passed, and today most market participants are aware of 29A, have taken that into account. And for all of these reasons, I do believe it should be retained. I will now hand it over to Sumant to continue and add his points as well.
Thank you so much, Aparna. I would only supplement what Aparna has mentioned, not repeat, or at least try not to repeat any, although of course I might emphasize one of the 2 points which he has made. I mean, those of you who would have done your homework would actually be surprised to see me on this side which propagates in favor of 29A, because many of you would have noticed or have found that when this ordinance was brought into effect on 23rd of November 2017, 6 days before that, I had written a very strong piece in the Financial Express expressing my reservations against any such law being brought in. And my reservations were largely based on the fact that what was being discussed at that point in time was, as Aparna mentioned, much more encompassing as it is today. In fact, it is in the ordinance, it was a little bit more than what it was in the bill that was tabled in the parliament. There is a history to that. I won't go into that, but that was my real concern. I was not per se against 29A. And the reason why I was not against 29A per se were as follows. One, I thought that given the economic policies that this government wanted to or aspired to introduce and the approach that they adopted, it was clear that they believed in constructive destruction. And they thought that in order to introduce a completely brand new thought process in the market, in particular to achieve a free market economy, a disciplined economy, an economy where you have a fresh breed of entrepreneurs, which survives alongside the family owned and controlled businesses, they thought that this would be a very good tool. In addition to the reasons that Aparna mentioned, that you can't just hand over the company back on to the same set of people who have destroyed it, and that too at a discount, because then you haven't solved the problem, you just kick the can down the lane. And that's not what IBC is meant to do. The second reason was that there was for the 70 years since the freedom India had, our independence, we felt there was a general sentiment in the market that there was a certain set of businesses that controlled the economy, the policy making, and had a dominating narrative in the economy. And it was important to break that sense of entitlement. What has been described by the chief economic advisor to the government as feudalism in the corporate sector. That certain set of people will believe that they can never be touched, they can never be reached, they're beyond and above the law, and therefore they need be, they're protected. And it was to break that sense of entitlement that it was important to send a very strong message. There was a lot of symbolism in this as well, and I think well taken. The third point, I think, also was that the market, the players, the policymakers understood that wherever the lenders felt that there was no trust deficit with the promoters and they could sleep in the same bed as the promoter, they would not any which ways take the company to insolvency, at least not themselves. And nor with the corporate debtor, they would resolve it outside through an out-of-court resolution, as was done in many cases. So from a short term, yes, it did create a kind of a tectonic shift of the plates. It did create a disruption, but that disruption was very well required. And I think it served a very good purpose. Yes, it was done in a very enthusiastic or perhaps over-enthusiastic way. And the law as it was written was something which probably included even those people who ought not to have, which have been corrected, not just, as Aparna was very rightly mentioned, by way of the amendments that took place, but even if you see the difference between the ordinance and the bill language, 3 corrections were made even before the bill was tabled in the parliament sometime in 6 months down the line. So the government never really intended to include in those who were bona fide defaulters, with whom the trust deficit could be bridged and who could have actually defaulted for reasons beyond their control. And there was no unscrupulous aspect involved, as the parliament, as the finance minister mentioned while he placed the bill in the parliament. So that if you see from the prism of a policy maker who's trying to discipline the market, who's trying to bring in a sea change in the mindset, a cultural shift, a behavioral change, you can't do it incrementally only. You need to at times really put the hammer down. So 29A was hammering the message down. And I think it has served its purpose fairly well if you were to see how the behavioral change, as Aparna mentioned, has taken place. Now, having said that, I'd like to make 2 more points. I mean, yes, I also believe that 29A cannot be there perpetually. It can't be there forever. You will need to phase it out over a period of time. And that should happen, as has been happening in the past, over the next 2 to 3 years, perhaps 4 years. Maybe even 5 years, we can live with that. We have seen Section 12A being brought in, that is a window opening for bona fide promoters who may have defaulted, but they still haven't really lost the trust deficit in that sense. And you can still make mends with the lenders, settle it and go out by 12A door. Same goes for the other amendments which we spoke about from 29A. I would also say that pre-pack, as also Aparna mentioned, is a big leap forward, not just in terms of a 29A alternative or giving a respite to those promoters who can still present a plan and win the confidence of more than 66%. But it is also, in a way, an introduction of a debtor in possession concept, so it is not. So if you see both these sides of 29A, the policymakers don't have an aversion to the promoters as a class as such. It is to sort of make sure that the honest will swim, float ashore, but those who have brought the company down and with which the creditors have no hope whatsoever, they just need to get, make way for those who can ultimately do well. And the second point that I want to make is the cost versus benefit analysis. At the end of the day, there is always a cost to any harsh policy that you make. And that is why we are debating that, is there a cost to this? Yes, there is a cost to it. There are certain cases where you would not find a resolution applicant. The company may have gone into liquidation or may go on into liquidation. Fair enough. But if you do the cost versus benefit analysis, and to a degree that we have done, we will find that despite 29A, we have seen a large number of resolutions. We have seen even the biggest of the cases, the steel industry, the cement one in the beginning, the big industry has come forward. So it is not that then vacuum was created. I mean, that vacuum was so quickly filled in. So I see no reason. When you see the cost versus benefit analysis, we've done very, very well for ourselves. Now, the only one last point that I'll make in the last 30, 40 seconds is that at the end of the day, any insolvency law, what is the meaning of the insolvency? The insolvency is in fact a process by which assets which are otherwise productive are lying locked in the hands of incompetent management, and you are actually freeing them through the insolvency process and transferring them into more able hands, in the hands of more able and competent managers, bringing them back into the economy so that they can create a churn into the economy, contribute to the GDP. That is the goal. The end objective is you have to find more competent, able managers. It doesn't matter whether you change them 3 times in the lifespan of an asset. You just need to find the most competent manager. And that is what insolvency is all about. So that 29 is in no way in conflict with that proposition. 10 minutes, I'm done, Ishan.
Thank you, 14, for managing time so well and some great arguments for the against team to respond to. Starting with Veena, floor is yours.
Thanks, Shana. And thanks to both Aparna and Sumant for their views too. Let me start. I think let's dial back 5 years from today, because the IBC has lived 5 years. And let's just look at the first few lines of the code. And I'm reading from the code. It is the preamble of the code. And I'm just going to read a few words. An act to consolidate and amend laws relating to blah, 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 to promote entrepreneurship and to establish the code, blah, 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 again, and balance the interest of all stakeholders. These are the 2 principles on which I'm going to base my argument. 1, to promote entrepreneurship, and 2, to balance the interest of all stakeholders. When we talk about 29A today, and I'm not even looking into the provisions of IBC, let's just look at the preamble. The preamble uses these 2 words. If we look at what the object of the legislation was, and nobody is questioning the fact that 29A, when it was introduced, was absolutely beneficial, needed, helpful, achieved it or its objective, did not achieve its objective. We are talking about 29A today as we come out of a pandemic, as we look at whether it has served its purpose and whether it needs to be continued or not be continued. To promote entrepreneurship, it's a very interesting word, because entrepreneurship effectively means business of the individual himself or herself, right? 29A goes against this principle in entirety. And the reason I say that is, if I have set up a company and my entire objective of having set that company up is a risk that the company would be taken away from me for a default which has happened, 29A just kills it, because the fear of failure today has been just multiplied to such a level because of 29A that people are scared to start off on their own. And we are talking about a country which has unicorns, which has various startups, which has various other entities which have, which have stories to write about. Will they continue? I'm not so sure. Today, if somebody comes and asks me as a lawyer whether they should set up a company, my answer to them probably would be, yeah, do so, but do so with some other person's money, because you never know when it will be taken away from you. And that hurt may not be that much stronger. So I think as we live through 5 years of the code, one of the things that I certainly feel very strongly about is this part about promoting entrepreneurship. And I think 29A completely kills it, because it's a very, like I said, we are not questioning the efficacy of 29A when it was introduced. Today, when we come out of a pandemic and we look at a country which has people whose brains are tuned to come up with ideas, 29A seems to go against that in entirety. The second interesting point is what I spoke about, which is balancing the interests of all the stakeholders. When you talk to any practitioner, nobody talks about the promoter who set up the company itself as a stakeholder. And that's just surprising, right? It's at the end of the day, a person has set up the company themselves, and the definition of stakeholder does not include them. That's just, according to me, again, goes against everything that IBC is intended to actually achieve. There are two other points that I want to cover. One is this entire bit about how IBC is entirely about resolution and not recovery. If the idea is resolution, especially for companies which, the big companies, the big NPAs are all spoken about, they have all either been cleaned up or not cleaned up and gone into liquidation. We are not now talking about the mid-sized companies, not the MSMEs, the mid-sized companies, which are most probably in genuine trouble because of the pandemic or otherwise, but genuine liquidity concerns. And my partner will speak about it a little more when he comes in. But we are talking about those companies, and we are talking about sectors where who knows the company the best, which other than the person who has set it up themselves. When we also talk about questionable antecedents, as my colleague spoke earlier, it's surprising because at the end of the day, we are talking about corporate governance, right? If a person is allowed to set up a company, what makes the person not eligible to run that company just because the company has gone into some trouble? It just doesn't sit well with what the code is intended to achieve, or what the code is intended to actually promote when they talk about promoting entrepreneurship or balancing the interest of all the stakeholders. We'll move on a bit to the statistics. When we look at how the IBC has evolved, and in the last 6-7 months, if you have opened any newspaper, you would have seen the word IBC. In most papers, you would have seen 5 years of IBC and the statistics around it. One of the most interesting statistic is the number of cases which have gone into liquidation. And just for the benefit of students, liquidation is effectively death of the company. I mean, yes, we do talk about liquidation as a going concern, but the value that a company gets in liquidation is effectively peanuts. It's, again, 29A is applicable there also. But when we still talk about liquidation, it effectively means winding up the company, closing the doors of the company forever. It's death of the company. 47 to 50% of the companies which have been referred to IBC have ended in liquidation. That means 50%. So your objective of resolution versus recovery is actually out of the window, because there is no resolution, there is no recovery. You have actually killed the company, and you have done that to 1 out of 2 cases. Every second case you have actually said, okay, this is about it, and that's it. You kill the company, let it go into liquidation. The other interesting statistics, especially after Suman spoke about 12A, after the introduction of 12A, 16% of the cases have been handed back over to the promoters. This brings us to the entire principle of why, when we look at the IBC, it is a creditor in control regime. The benefit that IBC has over anything else, it's not that companies can be just taken out of IBC, right? It's the creditors who decide that. The benefit that an IBC process gives is that it gives a clean slate. It allows, even if it is a promoter or even if it is somebody else who is taking over the company, it is a fresh leaf. It is a fresh start. So to that extent, if the commercial wisdom, if everybody talks about the commercial wisdom of COC, they will just not vote, irrespective of 29A. If they don't believe the promoter, they will just not vote. But is liquidation the ultimate solution? By taking out 29A, all you're doing is giving one more choice. And if it's not that the promoter gets to take his company without a bid process, it's just that they become eligible as a resolution applicant. They are not the resolution applicant. They are just going to be one of the others who are participating in the entire process. And the COC is wise enough. These are bankers and these are other financial creditors who have lent their money to this company over the years. They know the best. And if they actually feel, especially given forensic, given related parties checks, all that the RP does, if they still feel that the promoter is not worthy, they will just not vote for it. But why take that option away in the beginning itself? These are some of the grounds on which I very strongly believe that 29A has outlived its requirements and it has achieved its objective. And over to you, Spitto.
Thanks, Veena. So let me start by telling you a small story, just to give you context of what 29A does. Suppose you go to engineering school and you, in your first year, discover that engineering is not your cup of tea. You have failed the exam and you realize that this is not what you want to do. Then you decide at the end of year 1 to come to law school. You fill out a form and say, look, I'm not good at engineering. I'm going to do law because this is what I really like. And your university says, actually, sorry, but we can't let you do law. And you ask them, well, why? So they said, because you failed at engineering. That makes no sense. But it's true. And then the school also tells you that it's not only about you. In case your brother, sister, anybody in your family also failed at engineering, even then you're not entitled to do law. That is pretty much what 29A-C does. It's not, and if you look at the interpretation of it, it's not about the particular company in question. If you have got any NPA anywhere in the world, technically you're disqualified under 29A-C. Look at the biggest litigations that have happened in this space, right? Veena and I were associated with the Arcelor matter. What was the grounds on which Arcelor's eligibility under 29A-C was challenged? It had nothing to do with SR Steel. They were neither the promoters of SR Steel. They had not worked with SR Steel or anything in question. They had invested in another Indian company years back, had no history of appointing any directors or any management in that company. They themselves had written off that investment in about 5 years ago, 5-6 years ago, before the acquisition. No one was attending any meetings or shareholder meetings. It was a bad investment, which when the steel cycle happened, they wrote off. But they were held to be responsible for that and said, now that if you want to bid for SR Steel, you have to pay $1 billion for that asset. which was a bad investment, which you've written off, but you had no responsibility or no management or no role in what happened to the fortune of that company. And they of course paid and then, went on to do the acquisition, but that's a commercial call. But I'm pretty certain that everyone on this panel will agree that a lot of bidders at that time would have said, no, sorry, this doesn't make sense and we are not doing it. The other bidder whose eligibility was challenged with the Tata Group, saying that you are not 29A eligible. Somebody challenged JSW's eligibility under 29A. So when we talk about questionable promoters and is being, are supposed to be kept out, but what has happened in reality in all these cases is that it has allowed for people who want to delay a resolution plan or somehow derail a resolution plan to launch a witch hunt against the best of the best who are looking to turn around these assets. So it kind of defeats the intent. No one is questioning that the overall intent of the IBC. IBC is a law which serves a very good purpose in the economy, as Suman pointed out. No one is questioning the intent of 29A per se. Aparna and Suman did a very good job of highlighting the intent, the legislative intent. But between the intent and the law, there is a disconnect. If you're saying that I want to keep people who are willful defaulters out, which is one of the clauses, fine, that's fair. Someone who's been barred because he's committed an offense under the securities law and SEBI has barred him, you want to keep that person out, that again is understood. Where someone has been convicted of a wrongdoing and you don't want that person to be a party to a resolution process, that's fine. You want to keep certain elements out of it, which seems to be the original intent. That is not the problem. But the problem is the way the law has been drafted. It's so overarching that it has, it can be used, misused, and abused in many ways, and that has deterred a lot of people from participating in process, and secondly, delayed a lot of some insolvency resolution cases. And that is the issue with 29A, not the intent, not the overall IBC process. If you had a tightly worded provision which worked, there would be no debate. The reason we are having this debate is because it has led to many disputes which have lasted for years, many headlines in newspaper, which I'm sure all of us have read about and enjoyed. But that has caused the issue. And that needs what you really need is to water it down, have perhaps a tighter provision. The way 29A currently stands with this wide sort of ambit, it becomes a huge deterrent to the whole resolution process. Then there were a couple of things which Aparna sort of mentioned worth sort of discussing. She said that this 29A guarantees, that there will be a successful turnaround. Actually, nothing guarantees a successful turnaround, because if we're talking about the implementation of the plan per se, if you don't implement a court order, obviously you can go and approach a court seek remedy that an RA who was supposed to implement an order has not implemented order. Post implementation of the order, the inherent nature of business is that there will be business failure. Now, whether the person had successfully run a business earlier or not successfully run a business earlier is fairly irrelevant. So this, turnaround can only be done by people who've, successfully led a business. I'm not sure, because if someone has not, perhaps not done well in business, he may understand some of the pitfalls better and then may be able to better, turn around an asset. Similarly, just because someone has been successful with a particular asset does not necessarily mean that he will be successful in everything else that he or she does. So this turnaround theory is, again, I'm not sure how practically it works on the ground. Then I guess the last point is in terms of, when what we are seeing on the ground, when people are now trying to, the RP has to certify 29A compliance. Now no one knows what 29A compliance is in this country, honestly. And what happens is then a great data hunt begins, where you start asking for promoter's neighbors, passport, Aadhaar detail. All of this has to be collected. God knows why those are being collected, but this is being done. So when we're talking about which is an entity which is 29A compliant, for the global entities who are coming into India, you have to look through the world. Now something has happened in Bolivia, Chile, find information about it, put it together, send it to it. Is at the administrative difficulty that we've caused by this, major 29 exercise, which is a global exercise, because there's a clause there that says any of this happens anywhere in the world, that makes you 29A ineligible. Again, it creates a lot of practical issues and practical difficulties, which is again deterring people from participating in these processes. So the idea would be to water it down. If there is if it's limited to certain categories of people who've committed actual offenses, great. But beyond that, we should not have these sort of restrictions on promoters. If someone has been unsuccessful in a business, that's not a crime. And he should be allowed the opportunity to turn around any other business, so long as he has the means and to present a resolution plan. I don't see why failing at a business is an offense or a crime that you're disbarred from life from submitting a resolution or trying your luck at another business. That's, I think, our submission.
Can I go for the rebuttal first, Aparna, if you don't mind?
Yes, sure. Go ahead, Sumant.
Sure. I just want to, Shana, is it okay? I'm okay to go, or you want to make say something?
Thank you again, Steve. From a rebuttal perspective, we start with 4. You have about 5 to 7 minutes to rebut, and then there's a rebuttal option for 2 minutes.
Sure.
Go ahead.
Well, thank you, Shana. I just want to make 3 very quick points, 2 to Sudeep's and 1 to Veena. Yes, for Sudeep, I mean, your story of failed in engineering, disqualified to take law. I'm sorry, I mean, I don't think 29A is about that. 29A is about a story who is of an engineer student who took 3 crores loan, but didn't use it to buy books to pay fee, but buys a Mercedes and also buys a couple of cars for his sisters and brothers and father, takes them on a holiday. And therefore, why should you be given another loan or be trusted with your law admission as well and give another 2 current loans? I think it's about that. 29A is about having not conducted yourself well. But if you have failed because you could fail, I mean, anybody can fail, then yes, of course, it should be law or it should be, any other school that you should be entitled to. I don't think 29A is the story that you tell. The second also, I mean, the point that I wanted to make was about the fact that, I mean, I know I'm short of time, so maybe, Sudeep, this is the point that I'll lead with as sort of Veena is concerned. I mean, I think the point on entrepreneurship that you made, yes, I mean, I don't see any conflict between 29A and entrepreneurship, because the fact is one individual's loss is another's gain. So even if you are losing your company, somebody else is coming in and he's running it. So the entrepreneurship thrives and survives. And in fact, it is the survival of the fittest. The better one is the one who continues to, have the confidence in the market, continues to get exit financing, and continues to and has the opportunity to manage the assets. So yes, I mean, I can take your point on the entrepreneurship that yes, it raises the risk very high for those people, because if there is a default, you run the risk of losing the company. But that is exactly what 29 is all about, that you need to be diligent, you need to be careful. There has to be, there has to be good corporate governance, good corporate financial governance, and the whole ecosystem. And that's the sea change which is being sought to be brought by taking number of measures, including 29 being one of them. Over to you, Aparna.
Thank you, Sumant. Just a few other points, and I think I'll start with Veena's point on entrepreneurship, because just to add to what Sumant was saying on that, it's not that 29A per se would be killing entrepreneurship. The thing is that, what 29A does and what insolvency is about is that this is an entrepreneur that has defaulted and has also not been, if it's a situation where the banks, the creditors believe in the business, believe in the entrepreneur, and the entrepreneur has been, been able to convince its creditors that, I need a second chance, that I will be able to turn this around, there are many other options. They can do this outside of the IBC itself. And there's also Section 12A that is very useful in this context. So I don't think it's right to say that because of 29A that would, that entrepreneurs would be fearing failure to such an extent that they would not even start businesses. I don't think that's quite a stretch into what 29A is about. Secondly, I also, Veena mentioned the statistic about, 47 to 50% of companies that, go into IBC end up in liquidation. Again, I don't think we can relate that back to 29A. Many of these companies, a very large number of them, because IBC has only been functional now for 5 years, a lot of these companies are also legacy cases, which would have probably ended up in liquidation in any event. So I don't think, again, we can really make a causality from, the cases in liquidation and that's caused by 29A. In terms of Sudeep's points, first I want to clarify what I said. I don't think I meant that 29A would guarantee turnover. I don't think anything can guarantee a turnaround in any case. I mean, that is really up to a lot of factors. But the fact is that we all agree that to some extent there needs to be a limit, there needs to be eligibility criteria for who can actually submit resolution plans. And the reason for this is because we care about the resolution itself and the ability of the resolution plan to achieve a turnaround. At least that's the goal. Even it may or may not occur, and it's not the case that an entrepreneur who's failed once cannot be successful a second time, or even one who's failed several times can't be successful. But the fact is that we still do have some eligibility criteria that will increase the chances of a better turnaround. And lastly, I think the very quick point on, I know that sometimes the fact is that in some situations, 29A may inadvertently catch individuals or people that it's not intended to catch. But I think if you had one that didn't, for example, extend to connected persons or related parties, that would be gamed by promoters all the time. So there has to be, and I think it's easy to go into some anomalous situations and sort of make law from that. But I think there has to be a balance here. 29A has been watered down a little bit, and its very problematic provisions have been removed since then. So that was the last point I wanted to make here. Thank you.
Thank you so much, Aparna. Veena, Sudeep, for third rebuttal. Over to you.
Sure. Let me start. When we are talking about 29A going away, the impact of that is twofold. One is that it is, at the end of the day, it is an option to the creditor in a creditor-led regime to have one more person submit a bid. We are not saying that the promoter has a backdoor entry to take over his company back, right? We are saying there is an advantage there. Obviously, there are other regimes of RBI, but none of the regimes provide for a clean chit or a fresh start or anything which is effectively going to bind all the stakeholders, all the creditors. Any kind of RBI resolution that we talk about binds only Indian creditors. It doesn't bind foreign creditors. And any company of any value today would have foreign debt on its books. Therefore, a regime has to be there where it binds all the creditors and where it is just giving an option. It's not about anything in addition to an option that we are seeking. Secondly, as far as the disqualifications in 29A are concerned, it seems like everybody has painted the promoters with the brush of ye to chor hai. It's like it's that entire mentality of this person has done something wrong. The mentality that the person has done something wrong because of economic situations. How many businesses, how many restaurants do we see having closed down just around us, right? Does it mean all of them should be taken into IBC and that person should not come back in control? It just sounds ridiculous to some extent. So As far as willful defaulters, and I think Sudeep covered this to some extent, as far as willful defaulters are concerned, as far as people with colorable antecedents are concerned, there is a regime for it. There is no Indian financing which can be availed by them. If that's the limit of 29A, we wouldn't be having this debate. But it goes beyond that, and that's where we are saying it should be done away with. And obviously, it has achieved its objective at a time when everybody used to say that people have rich promoters and a poor company. I don't think anybody says that. 5 years ago, all of us are restructuring lawyers. We would have seen 5-6 years ago, companies in default. To even get a meeting as a banker with the company after they have defaulted used to be a nightmare. Today, before default, you will have the company calling you, asking you to restructure. So when we talk about discipline, that discipline is already in the market today. Sudeep, over to you.
Thanks, Veena. Just a couple of quick points. And like Veena said, we don't have a problem with willful defaulters. So to Sumant's example, that someone uses a student loan to buy a Mercedes, yeah, that's problematic. Sure, disbar that. That's the category of willful defaulter, which is a separate head under 29A. Fine, we don't have a problem with that. But simply because you defaulted on a student loan because you can't find a job, that certainly should not be a criteria for you being disbarred from anything. So that is the distinction I think we are trying to do. The second thing Aparna said about anomaly, that these are one-odd situations. But you look at the case law, and she's as familiar with it as I am. There's a huge amount of litigation. Clearly, this is not some hypothetical example, but if you look at all the litigation, all the noise around IBC, a lot of it generates from 29A and the related issues. So it's not a random sort of hypothetical that we are debating. It's actually a multiple real life situations, and therefore it needs fixing. I think that was the second point we wanted to make. Yeah, that's it.
All right. Thank you so much. Let's just see how this debate has ended in terms of for and against, and then we'll just have a chat about 29A and the related party restrictions. No specific focus. Shubham, please, second poll. IT, second poll, please. Okay, the poll will be open 5 more seconds for those of you who want to vote, but there seems to be a complete swing. We started with 100% for, we're now at 71% against, so clearly.
Yeah, well done, Sudeep and Veena.
So congratulations against, clearly, okay, now at 75%, so we just stop the poll and share results. Congratulations, Veena and Sudeep. Thank you very much.
Congratulations.
For team, clearly with the 100% that you started with, there seems to be a complete tilt in terms of the manner in which Section 29A has been admitted and the ambiguity around it. So now that the debate is over, I just wanted to go around the table and sort of get a sense of what are your thoughts on the related parties, specifically restrictions that have been introduced in Section 29A, and how are you combating it? Because there are, I know all of you at some point are looking at both sides, where you want to perhaps qualify as a related party, and when you don't want to qualify as a related party based on who all of you are representing in terms of COCs, our IPs, or the bidder itself, or the promoter and the company. So I just wanted to get a sense of how wide do you think the net has actually been cast? And you are also looking at a situation where you are looking at certain sectoral exceptions that have been made, owing to the exceptions that have been made within the IBC itself, which is with the MSMEs. Is it with the idea that, look, if we do away with the promoter, then, or the company itself, nobody's going to buy that MSME because there's perhaps no fixed asset? I just wanted to go around the table and also let my students ask a question or two, because we've spent a lot of time on looking at 29A, because it is sort of the cornerstone on which resolution in IBC is based on. So whoever wants to go fast, and over to you. Nobody wants to go further. You're all smiling at me.
No, I mean, I'm happy to make some comments, Ishana. If you see, I was a little mild when I mentioned about, my views on 29A. I was in a peculiar situation, as I was discussing with Aparna yesterday, because we both are known opponents of 29A, and my views on 29A are so well known that I know that it upsets so many people at the policy level. Because my 17th November article is something which the industry association sent as a representation to the Prime Minister's office and everything. And, I know, so it did create a lot of this, and my views are quite well known. Till about a month ago in a very high level meeting, somebody asked me, what do you think about 29A now? So 29A is something which has, in terms of, the problem is that, we've gone a little overboard in terms of including the related parties in particular. I think that's where the problem is. The willful defaulter is all right. And I think NPA with 1 year ability to sort of pay is all right. Guarantor who has not been able to pay, if guarantees invoked is fine. But criminal conviction also is fine. But I think everything else, I think, is avoidable. And I won't be surprised in 2 years from now, you will see 29A shrink tremendously and stop at these 3-4 clauses that I just mentioned. Because we're doing more of a disservice than a service as far as the related parties are concerned. So all the points that Deep and Veena made are very valid points. Since we are not in the debate anymore, these are very logical points, and I think that's how we need to approach 29. It may not have served its entire purpose or its full purpose, but it has done a little bit. So but I would be wary of, taking it out overnight. I think it needs to be phased out over the next 2 years, is how I feel it. It should be done. And I think the banks should probably use 12A as much as they can in the meantime. One other way of diluting could be bringing the prepacks for the other companies as well. Make it a bit more simpler than what it is at the moment. MSME framework is too complex, and that's why it hasn't really taken off. And that will happen. It's the market, what the market demands, what ultimately the policy is all about, isn't it? You can't just be sitting and making policy just for the sake of it. So you will see very soon these changes happening, hopefully.
Go ahead, Sudeep. Thanks a lot for that, Sumant.
No, it was fun because essentially I thought I was arguing Sumant's position given all the stuff that he's and to argue against someone on using his position was fun.
Yeah, I know. I mean, there are a lot of people, I have to tell you, with higher positions who didn't talk to me for many weeks on this position, because I do work, as you all know, with policymakers quite a lot. So to be seen as taking this strong position so openly, which I'm a bit discreet when you talk in the meeting rooms about your opposition, but I normally don't write as strongly. But this one, and I tell you what, the point that I have found the most difficult to deal was with Veena's point on entrepreneurship. Because if you see my article of 17th of November, the entire connect is that it is a big blow to the entrepreneurship, the spirit of entrepreneur. A young entrepreneur, I mean, she gave the example of restaurant, but any entrepreneur, who has invested 2 crores of his own hard-earned money, and he's borrowed the rest, and if he can't do something about it, his brother can't do anything about it, but there's a default. It is very problematic. It does affect entrepreneurship in a big way. And I think we won't see its implications as short term. But the flight of capital, which we generally hear about in the economic parlance in the sector, that is a flight of capital that is taking place. It's not just the big companies or others, because of fear of these kind of things. Generally, people think it's fine to then have your headquarters in Singapore and then have the maybe the facility somewhere in India, but have your restructuring ability elsewhere. So forum shopping is what it will give rise to, it will encourage if you don't deal with it.
The other interesting thing is, like, 29A is not there in any other jurisdiction, right?
Yes,
India is the only country which seems to have.
I mean, I don't know. I really think, and you'll be surprised. I mean, I don't know. I mean, I shouldn't be talking too much off the line, but I can tell you that a lot of people in the government were also opposed to it. I mean, including some very senior position, including ministers. I can't name anybody. So this was not really something there was complete unanimity about. And rightly so. People who understand insolvency, people who understand, how it would have impacted, they opposed it, including people in position who ultimately had to sign it and defend it. And obviously, you can't defend it with conviction. I mean, I couldn't. Obviously, I was not able to defend it with conviction. That's why we lost it, isn't it? Today, as the debate. That's what happens. I mean, it comes across, isn't it? If you're trying to defend the indefensible, then intelligent people and your children, your students are smart, Shana. I mean, they can understand that.
Thanks, Sumant. I think I must confess, I purposely put you for because sometimes I must confess there, because I thought the best arguments are formed for if you've already thought against. So I purposely did. But clearly there is a larger and a deeper question in terms of the legal loophole that has been created, and that's also.
I know hard feelings for that.
Parna.
No, it was quite a challenge, actually. Fun challenge, I think, to actually think of arguments for, because most of the time we've been thinking about, all the issues and concerns with 29. And I think as a practitioner, especially, I think there are lots of even if there's just the process of ensuring that compliance is quite a nightmare in many cases. So I think even just coming from that.
Yeah, I mean, Ashdeep made that point, I mean, to do the due diligence, unnecessarily avoidable due diligence, across countries, across a large number of conglomerate, I mean, these companies, relatives, individuals is just completely avoidable. And I hope, corrections will happen. Corrections will continue to happen. But I don't see, and I wouldn't also advocate that it should be dropped off one fine day. I think it has to be phased out, because the repercussions of dropping it one fine day from a reputational point of view, from a point of view of also what damage it may cause, I think that may not be proper. So we have to phase it out.
Just to kind of supplement what Sumant is saying, that some of these issues have been fixed either through amendments The earlier version, Aparna, I think, was pointing it out. The 29A that started off was even much more wide-reaching, and then they sort of narrowed it down. Courts have also given some interpretation. There was Supreme Court, for example, on this whole issue of brothers and related parties, said you need to actually have a business connection, which was sensible, and Justice Nariman sort of put that in a judgment. So there has been course correction both from the government and the legislation, and also the courts have also read it down in situations to make it more sensible. So, it's not all doom and gloom. There is obviously path correction that happens over the few years to make the overall IBC work.
Yeah, and also, just also to respond to what Veena mentioned, that about, you can't paint everybody with the same brush. Deeply also mentioned. So, and my article of 17th November ended with that note only, that every person whose name is Prem Chopra is not a villain, right? Yeah, you have to, you can't just view everybody from the same prism. Yeah, that was a. But ठीक है, गेहूं के साथ धुन पिसता है. So we've had some collateral damage, surely. But yeah, I think in larger piece of, game life, you see it happens. Yeah.
Thank you so much. That was very insightful. I know we've actually been great on time, so we have about 5 to 10 minutes, and maybe if any of my students have a question, we could take that and then close off. If that's okay. Guys, any questions? We have sort of racked our brains and spent an entire month on this particular topic. Trying to kind of look at corners. No need to be shy. Please go ahead and ask. Anybody? Nobody? Yes, I can't see who's raised their hand. Yeah, Ishan, go ahead.
Ma'am, I just wanted to ask the speakers that recently, not recently, but from at least in the last year, Mr. Raghuram Rajan has also been sort of campaigning for an alternate sort of a restructuring scheme where you allow, where you allow sort of an alternate mechanism to be set up, especially during COVID times. And he has been arguing from a banking law perspective and citing that the loan recoveries have been critically low in India as comparison to the rest of the world. So how feasible is it that a COVID specific solution sort of gets implemented?
I think RBI did introduce a COVID relief package, which was amended once sometime last year in August. There was time given till December and thereafter till March. I think any RBI-led regime has an inherent flaw in it, and it's not RBI's fault that there is a flaw. It doesn't bind everyone. RBI binds only the creditors to whom, or only the lenders to whom they are acting as a governing body, right? If they don't govern foreign banks, which are giving money on a cross-border basis, or FPIs, which are giving capital to Indian entities. So that is one inherent problem. Otherwise, I think any measure of resolution is obviously welcome, but the problem with anything of that nature coming from RBI is that it's not necessarily binding on everyone.
Right. Thank you for the response, ma'am. And that was sort of the confusion that I also had with as to what would be the applicability of reforms from the RBI specifically on foreign lenders. So thank you.
My pleasure.
No, but that's also sort of an interesting element in terms of capitalization requirements, and can actually persons who actually manage companies go through the restructuring process, perhaps. And we've seen the prudential norms not actually see the light of the day just yet before it was already in pandemic, but let's see, from an academic perspective, it's always great to see numbers and then say it's not working. And I'll leave it up to you guys to actually interpret and do the work on a uphill sort of a thing. But I think we don't have any more questions. I must say I'm very grateful for all of you to actually have been a part of this launchpad and giving me your available hours. So thank you very much. Very, very grateful for that. And given the way in which we've been able to have a very candid conversation, I do think that it's a lot of food for thought for the next generation who are actually thinking and going to be perhaps your juniors are able to embrace and understand the law a little more deeply than just reading it and then figuring it out the hard way. So I hope it works both ways. And I want to say thank you very much to all of you. Thank you.
Thank you, Ashana, for having us. I enjoyed it. It was a pleasure to be with Aparna, Deep, and Veena. And it's always a pleasure to be able to do anything with it for the students.
Thank you.
Thank you, Shana. Thank you for having all of us over. It was great fun debating.
Thank you, Ishana. It was great. Thank you.
Thank you. Bye, everyone. Have a good evening.